Special needs trusts are designed for special needs children, children with disabilities, and especially those receiving government benefits such as Social Security income, SSI, and Medicaid. The Special Needs Trust is relatively new to the law. Prior to the time when we had special needs trusts, parents would simply disinherit their special needs children because upon receiving inheritance, a special needs child would lose their government benefits. So the legislatures around the country determined back in the 90s that it would be public policy to allow parents to leave money to special needs children to pay over and above what the government paid, because the government was not getting this inheritance money anyway because the kids are being disenfranchised. And there are actually two types of special needs trusts. There's the first party trust and the third party trust. The first party trust is actually created by the special needs person themselves, assuming that they have legal capacity to create a document that may be disabled in some ways, but they still have legal capacity and they can sign a trust agreement. And this is used for money that they may have received by an inheritance, a personal injury award, or even earnings before or possibly during or after the time that they become disabled. The difference between this first party trust and a third party trust is significant. A first party trust, a special needs trust that is, uses the special needs person's own assets. The key distinction there is the first party trust has a payback provision. So whatever is not used on the death of the special needs person will go back towards paying the benefits to Social Security and Medicaid. The third party trust is the more traditional one, and this is the one I was talking about earlier, where parents are disinheriting children. Now parents are allowed to leave it to a special needs child, and there's no payback provision, which means any money left after the disabled child dies will go to presumably other heirs that the parents have chosen, usually brothers and sisters. You have issues about funding these special needs trusts. Often a special needs child doesn't need the same amount as other children. On the other hand, sometimes they need more than the other children. So it requires some skill and expertise on the part of the lawyer to discuss some of these options. Are you going to give them a larger share in inheritance? Will you take out insurance to pay the extra money? And then another key consideration, who is going to be the trustee? And this can be very problematic. This is where the skill and experience of the lawyer comes in, going over the various options for trustees with the parents. Sometimes it's one or more of the siblings. Sometimes one or more of the siblings either don't want to take on that responsibility, or they live too remotely. They can't take on the responsibility. And now we're considering our options. We can use banks, we can use trust companies, we can use the law office or the lawyer that created the special needs trust. Naturally, there's pros and cons to each of those, so those will be discussed with the client. And then finally, an important feature of special needs trust is something called the letter of intent. A letter of intent is a letter written by the parents to the potential trustee, explaining what the likes and dislikes are of the particular person. What are their hot buttons? What gets them upset? The parent who intimately knows the child needs to pass on some of that wisdom to the potential trustee or caregiver. So the special needs trust is something generally prepared by elder law estate planning attorneys. It requires a lot of empathy. It's a difficult situation for the parents. It's difficult for the family. Within one generation, in any family, 1 in 4 families has a special needs child in America. This is remarkably high. And the other thing about special needs children is historically, they would die before their parents. They had a much lower life expectancy. It's only because of advances in medical science and better nutrition now that in the last few decades, special needs children are outliving their parents and creating these difficulties about who's going to care for them, what services, what assets, etc. We have a new law, actually. It's called the ABLE Act. ABLE is the acronym. And it's a new law that allows special needs children to create their own special needs trusts. Traditionally, only a parent or grandparent or a court could set it up. So if you didn't have a parent or grandparent, or the parents died or they're incapacitated, and the grandparents are deceased, you were going to court, asking the court to set up the trust, and that's a lengthy, time-consuming procedure. Now the government wants to empower our special needs citizens and allow them to create their own. So they can open a bank account, that's special needs. It's called an ABLE account, and they can actually set up a special needs trust. It's a huge concern. A parent can have 3 or 4 children, and all their concern goes to the special needs child. It's like the tongue always turns to the aching tooth. So they get the focus and attention. So sometimes you actually have to help the client turn their attention away from the special needs child to make it fair to the other children. Because if the other children perceive it's unfair and they have to act as the caregivers, it can create resentment, even animosity. So we want to make sure that everybody is treated fairly and that the focus, while the special needs child is taken care of, they don't become the exclusive focus of the parents' issues. The experienced elder law estate planning lawyer is primarily a social worker with knowledge of the law. So it's a social work service. People have to feel, or the old expression, people don't care how much you know until they know how much you care. So actually, unless they can feel that you care and you're concerned, the information doesn't go in. You can't actually get it across. So you have to get people to relax, let them know you're there, you care, you have options, and that's our job. Give people the options. Sometimes there's 2 or 3 options. What works best for you, and let the client decide based on being fully informed.